Lord, bring this in the list today as to be mentioned. Publish a supplementary list and then make the correction.
Lord, I may be permitted to file an memorandum of appeal without certified copy of the.
Why?
My lord, this is passed in principal bench, my lord. The certified copy is not available, my lord. The leave be permitted to file.
When was it applied for? Well, what is the date of the order?
Not the date of the order is 14 June 2024.
No, sorry.
But we have gone to Mlad to apply for certified copy, but they have refused Mlad to take. They said that the file is in the main principal bench along with the order.
So from June, we are in the end of December. No leave granted, obtain certified copy and then file.
Blair.
Item 1, here NDPS 2024.
Lordship, I am appealing for the petitioner hearing.
For the respondent.
When taken in custody?
From May
May.
2024. Almost 215 days.
There are 9 accused. One by one, all together 9 accused persons were arrested. Allegation that illegal possession of methamphetamine.
Quantity?
Quantity from this accused 200 grams.
So it doesn't fall within this small
Commercial.
commercial.
More than intermediate.
Right.
Up to 3 grams is available.
Yes.
50 grams is the intermediate. After 50 grams is a commercial.
And 200 grams.
200 grams. And Lordship, there is a big racket.
Lordship,
9 accused persons have been arrested in this case. Supplementary charge sheet yet to be submitted. More accused person yet to be arrested because it was a big racket.
Why supplementary? Has
Regarding
the
some CDR call details, bank details, transaction.
has the charge sheet been filed?
Charge sheet already filed.
All right.
way back in September.
Supplementary has been prepared.
Main charge sheet already filed, Lordship. So my objection, Lordship, kindly appreciate 200 grams of methamphetamine.
Lordship, let me
It is
make
a commercial quantity. Amendment is there.
Lordship,
Cannot be granted.
Section 27A, 29.
Lordship, let me make my submissions, my case,
Yes.
so that Lordship, this particular case has been initiated in the month of April 2020, 26 April 2024. There is a credible information received to the SHO PS CCS that one of the accused T. Naveen Kumar having a possession of methamphetamine. This after the raid has been conducted, 31 grams of methamphetamine has been recovered from the T. Naveen, and he was subsequently arrested. He is one of the first accused on the FIR. After subsequently during the interrogation, has really during the interrogation he have disclosed that one of the accused name is Sanjay Majumdar. Is another second accused. The both have been interrogated together. The both of them have stated that this particular methamphetamine has been brought from the Little Anbar. It's a Hadbe Island. This was the case, and subsequently the police has went to the Hadbe Island. Their investigation has been conducted. As per the investigation, if you want to see the page, my charge sheet page number 27, they have stated the two names is one of the accused name is Bittu Girami. If my charge sheet as per the prosecution case, if you are on a Lordship, come to the page number 26. Page number 27.
Right.
Yes, after they proceed to Hadbe, they interrogated one of the accused, Bittu Girami. As per the prosecution case, the Bittu Girami has disclosed that he handed over 200 grams to one Saurabh Dali, who is a resident of Hadbe, Little Andaman, after the disclosure made by the Bittu Girami, which was informed to SI Seema Mobe. After that, subsequently, they have went for to the petitioner's house. After the raid was conducted, their notice, section 50 notice has served. No recovery from my personal possession, nor from my house. If you want to see the next page, page number 28, of the charge sheet. Page number 28 of the charge sheet. The methamphetamine from the bitogram he has hidden in the coconut form of one Vijay gain, which is away from 10 to 15 meters away from the residing of Saurabh Dal. This was the case of the prosecution. As per the prosecution case, this particular contraband, which was not seized from my personal possession nor from my house, it has been directly seized from the some others plantation, which name in this particular land is
So
already
whether it has been submitted that it's a racket going on.
Lordship, already this in this particular case, there are altogether.
Not into- Sorry,
Lordship, there is a case
Please come.
because Lordship, my case is very genuine. My Lordship, they have planted upon me. If you honestly, the page number 47 on once
the petitioner is in
because
custody,
already in
is
Lordship,
in custody from which date?
7/5/2024.
7th May 2024.
In the month of September, they filed the charge sheet. Charge is still not framed, Your Lordship.
Very well. Charge sheet has already been filed. Stop. It has been found that the petitioner was involved in learned counsel for learned PP submits that the petitioner is a part of a racket in respect of the contraband drug methamphetamine right, check the spelling please. Stop. The we have perused the order passed by the learned. Where is it? Did you apply for bail there?
Yes, Lordship. On
Yes,
7
order passed by the learned special court within bracket NDPS.
on 7/10/2024.
The quantity which has been recovered from the accused persons, of which the petitioner is a racket, is a part, is of commercial quantity. Stop. The court is not inclined to allow the prayer for bail made by the petitioner at this stage. Stop. The prayer for bail stands rejected.
Lordship, let the direction can be given to conclude because the charge sheet is filed in the way back in the month of September, Lordship.
The bar of section 37 of the NDPS Act is also there. Is also staring at the face. Yes.
Lordship, my only submission is that charge sheet is filed in the month of September. We are in the December till they
No,
not
right on
not
one more
frame the
line.
charge and all.
The PP, the learned PP submits that the steps are being taken for filing supplementary charge sheet. You can take these back. What is the
Yes.
use of keeping this? Is there any requirement of keeping this?
No.
Return it.
Obliged, Lord.
Next one is also same
Then 55.
from the petitioner.
Use policy.
Very well.
Another 10 gram, only 5 minutes. Only 5 minutes.
5.
3 minutes, Lord. 3 minutes. 3 minutes.
You have to ration time.
Yes, Lord. Yes, Lord. Yes.
Lordship, 59 of my bail application, page number 15. In that, Lordship, total 6% recovery were made, Lordship.
Yes.
And they are in the place of 31 gram from Naveen Kumar, 18 gram from Sanjeev Majumdar, 4.36 from Ishwar Rao, 45 plus 10 gram, that is 55 gram from Sridham Khalko,
200 gram from accused Bittu Garami and 200 gram from Saurabh Dali. You know, I have given the two seizure list here. First seizure list comprising of 45 gram that we seized from the prime accused Bittu Garami's home. Can you appreciate that? And second, after 2 days, 10 grams seized from the home of Shriram Khalku, from the home. Lordship, kindly appreciate this case was initiated in the month of April. Subsequently, when the police investigation team went to Hadbe, they were searching for the prime accused Bittu Garami. Lordship, page number 51, 52, 53, 54, 55. It will show that there is a telephone transaction and also money transaction between the other accused person with Bittu Garami. There is no money transaction with the accused person Shriram Khalku. You know, kindly appreciate if I'm not admitting for the sake of argument, Your Honor, if any of the transaction, my case comes under intermediate quantity. 0 to 2 gram is small quantity, 2 to 50 gram is intermediate quantity, more than 50 gram is commercial quantity. The rigor under 37, because of 20 to 22C, that is commercial quantity, will not apply. 27A, financing will not apply because there is no monetary transaction with me. As such, Your Honor, Lordship, I have a very good case for Lordship of bail. Kindly appreciate Lordship. Also, I have no antecedent. No case of NDPS ever happened on me, Lordship. I am a local resident to the island, Lordship. I am in custody for 230 days. Charge sheet file, Lordship. Any condition, Lordship.
The moment the PP submits that you are a part of the racket, all these things.
Lordship, one thing. Lordship, kindly appreciate the Caesar are very important, Lordship. The Caesar, the list that.
Yes.
Lordship, the Caesar list, Lordship, kindly appreciate that. It was not.
No, sorry, sir. You please wait for some more time.
Lordship, I'm 230
Let
days
us
custody,
take order.
Lordship.
One more line to be added. The quantity of methamphetamine recovered from the custody of the petitioner is 55 grams. Nothing doing, sir. I'm very sorry.
All right.
For respondent, my lord.
Here, Your Lordship, I have gone through the list. Central list, I have gone through that list. It is not there. That is the fact. No, Your Lordship, at that relevant point of time, neither the authorities were having that list, even the tribunal was not having that list. But the cases have gone against me, Your Lordship, the authorities, believing the district collector's contention, terminated. Why I wanted that I should raise an inquiry for this particular purpose. I'm submitting. This is not a case of false certificate. It's not a case of false certificate. I have got the advertisement, just my client has given me yesterday. In the advertisement, they have not asked for OBC certificate. They have asked for community certificate. In the advertisement, I have submitted community.
What is community certificate?
This is what is community. That is to which caste I belong. That is.
Did you take the benefit? Did you take the benefit of reservation?
No, Your Lordship, that's what I'm coming to that. It's my specific case in my application that when the advertisement, there was no specific relaxation given to any reserve category. I applied under OBC. I'm submitting, but Your Lordship, when the selection took place, I came second in number, which was when Your Lordship knows about the decision of the Honorable Supreme Court that if a reserved category candidate comes on his own merit, then he will not be considered as a reserve. He will be considered as unreserved. I have specific case in my application, even before the tribunal, that in the selection, ultimate selection result.
So your submission, main submission is that you did not take the benefit of reservation and accordingly, the steps that are taken.
I have already stated to the authorities that you bring the merit list. It will be proved because if I am on.
How many vacancies were there?
There were from, I have specifically stated here, Your Lordship, in the distance. Para C, page number 6 of my writ application, paragraph C. I have stated, it's not that I have not made out a case.
Yes, 10 posts advertised.
10 posts advertised, so far as the petition.
7 posts were meant for general and 3 posts for OBC. That
Yes.
means there were reservation and you came in the second position of the list.
The petitioner was third in the merit list.
Petitioner was third in the merit list. So you are transposed to the top level.
Yes, Your Lordship. So this is the reason why I wanted that the inquiry should be done, and if it is found, but yes, I am in the merit position, and I should be my position should be converted to general category, my job will be protected. And the last, not the least, Your Lordship, 2018 interim order was there. I accept, because of which they could not implement the intervention. 2018, when I filed the application before the tribunal, I prayed for an interim order. It was rejected. Even after that, they have not terminated me because I was posted at Kachal Island and I was required there. 6 years passed. No action has been taken to terminate me. Still, I am in service. What my submission is that they can look into this particular issue. If I am coming under the general category, I will be protected. Only 6 years is left for retirement.
What is the observation of the tribunal? Did you make out this case before the tribunal?
Yes,
Please show.
original application.
Did the court enter into this?
No, no. Kindly come to page number 34, paragraph E. This is the original application where I have specifically stated about this.
It is the same thing.
Yes.
Yes,
No, this was never argued before
Not
the
argued.
tribunal. And
assuming it was not argued, what
argued.
is your submission?
my submission is that the application may be seen, my lord.
Which
Page number
application?
84.
Page?
Page number 84, R1. The application
Can you tell me?
for the post of watchman.
Can you tell us the merit position of the petitioner in the selection test?
This stage I cannot.
You
write,
cannot
madam.
file an affidavit. The petitioner has made out a case that there were 10 posts advertised by the authority, out of which 7 were meant for general category and 3 for OBC. Stop. The petitioner secured 3rd position in the merit list, and his case for appointment was considered in the general category. Stop. The aforesaid issue has not been taken into consideration by the tribunal at the time of deciding the case. Stop. Paragraph. Learned counsel representing the respondent authority is not aware of the merit position of the petitioner in the merit list. Stop. If the petitioner secures higher marks than the other general category candidates, then his case is liable to be considered as a general category candidate, and he will not be required to take the benefit of reservation. Stop. Paragraph. To ascertain the position of the petitioner in the merit panel, comma, the authority is directed to file an affidavit disclosing the merit list where the name of the petitioner appears. Stop. Such affidavit shall be prepared by, how soon can you do it? 30th of December?
No, my lord, it is a
No.
old case.
It will take more time. Very well. 30th of January 2025. Let the matter appear in the list of the circuit bench for the month of February 2025. Stop. The respondents are restrained from taking any coercive steps against the petitioner till the end of the circuit for the month of February 2025.
One submission, my lord, he was
Yes.
considered in the OBC, not in the general.
Yes, if he can be transposed to the general category, why the benefit of OBC reservation will be given?
My lord, some other person might have been appointed in the general category, then he is not a party here. It will be.
Till you disclose who is the person who has been appointed, how will that person be made a party? The
No, no, all
petitioner
along-
is not supposed to
All
know.
along the appointment is under OBC category.
You bring your document. It's over. Supplementary list, let it come, you make the order and get it signed.
Many methods are in my
Finish up the criminal appeal judgment.
I am worrying for that.
Any mentioning not in the list? Any mentioning in the list? Item number on WPS 653 of 2024.
As for the responding. Request to be working with this. I would really thanks for adding my opposition.
Very well. Learned counsel representing the respondents seeks time to file affidavit in the matter. Stop. Let affidavit in opposition be prepared and served by the first week of January 2025. Reply, if any, be filed within a fortnight thereafter. Stop. Liberty to mention for hearing before the available circuit bench.
Okay.
My lord, I am for the petitioner, my lord. It is that matter, my lord, lordship directed me to produce the original license. No, my lord directed me to produce the license. If license is there, you have to accept the premium. It was not traceable, yeah, it was missed in my house.
How did you get it?
Something else. You say something else. What is that? Something. This is the original license, my lord.
1 minute.
Page 66.
1 minute. Acceptance of premium.
It was given to me. What no? For other persons, my lord, they issued the license also. Premium acceptance.
Learned advocate representing the petitioner produces before this court a license alleged license to occupy land for house site in form caps AG-1 . By the Assistant Commissioner. On 5th of October 1989. And submits that the same is the original of the license.
Copy enclosed at page 66 of the writ application.
Copy of which is enclosed at page 66 of the writ petition. Stop paragraph. The respondent authorities have refused to accept premium from the petitioner as the genuineness of the license relied upon by him could not be ascertained.
No, my lord, file is not traceable. I
And as the file is not
I
traceable,
obtained the copy under the RTA Act also.
as the original file was not
My
traceable.
lord, this may be seen, my lord, and I obtained the copy from
Yes,
the
yes,
office.
it is annexed.
No, copy enclosed. I obtained the RTA from the office.
But then this is also annexed. I remember seeing this document in your writ petition.
Yes, page 66, that is page
Yes.
66.
And so next, as the petitioner has claimed that he is in possession of the original license issued by the authority way back in 1989. Accordingly, the petitioner is directed to produce the said license before the, who is the authority?
Deputy Commissioner, my lord.
Before the Deputy Commissioner. Within a fortnight from date. Stop. The Deputy Commissioner shall ascertain the veracity of the said document and take necessary consequential steps to accept premium from the petitioner if the said license is found to be genuine.
My lord, may I submit one thing, my lord? The impugned order, they said that file, they are not disputing the license. They say file is not traceable. For that reason, we cannot.
For that reason, they need to reconstruct the file.
Yes.
Then, if the document of the if the license produced by the petitioner is found to be original, comma, then steps shall be taken by the authority to reconstruct the file so that the prayer of the petitioner can be proceeded with in accordance with law.
Making payment of premium, man.
Yes, yes, for acceptance of your premium. That is your prayer. Steps shall be taken by the authority at the earliest, but positively within a period of 6 weeks from the date, 8 weeks from the date of production of the original before the Deputy Commissioner.
Yes, the impugned order is required to be set aside, man. Page 64. Second page may be seen.
It has only been disposed of. It does not say it has been rejected.
Cannot accede to the this juncture.
Right. At this juncture.
Yes.
That means at that stage. In future, they can do it.
Should go, my lord. Otherwise, it will be retained. The DC will say that already we have submitted.
Very well. The impugned order of the Deputy Commissioner dated 6th of December 2017.
6.
At the top, 64, it is written 6.
6. Sign.
Oh, sign
is 7th and date is for 5th. 5th, 6th, 7th. 3 dates are there.
5th/6th/7th December 2024. Annexed at pages 64 and 65 of the writ petition shall not be given effect to.
I am deeply obliged.
Take back.
Item 3, WPS 679 of 2024.
Yes. What does your report say? Demarcation of the plot. All right.
It's not subdivided,
Yes,
so it will not be demarcated. A boundary can be demarcated, but not this portion, since the other potencies.
are also there. But then, does the petitioner have any deed or something from where the boundaries of your land can be identified? Sale deed is there. So 200 square feet, who is going to identify which is this 200 square feet out of the 2,000 square feet?
They have filed the report before the collector in it by saying that my land has not been taken. How they have filed that report, madam?
Listen, there are 10,
Others,
there are 10,
kindly see once, madam, page
28.
28. Starts from 27.
Yes,
That is the survey number mentioned, 144/2/P.
right.
Madam, out of 144/2/P, total area is mentioned 0.2207 acres. Madam, out of that, some person's land has been taken.
Right.
All got 200, some persons got taken and 3 persons left out. Now in the ROR, records of right, these 3 persons names are there. That means they have identified other persons plot.
What
How
about,
they have identified.
what about the 3 persons land?
They have not taken.
They have not taken,
Other
but then
persons from the.
try
from
to
the
understand.
state,
Try to understand, there are 3 whose land have not been taken, right? How will the authority know out of that 3 which is your land?
How the authority came to know that those persons whose land has been taken, their own land, because it was.
The authority has already taken certain portion and it is for them. Do you say that your land falls within the acquired land? You don't. You
We don't
say,
know. Yeah,
you
as per-
say that your land has not been acquired,
Because as per this report.
right?
In my first application, I said the others' land has been acquired, my land also been acquired, I have not given with the compensation. I have not given with the compensation. To collector area, I have given that letter, madam. In response to that, this has been given by the. So, madam, it was a chunk of land, it was a big piece of land. Out of that, some has been taken. How that portion has been taken, madam? Because it was a single sale date.
Single sale it for the whole,
Whole,
how can that be?
madam,
There are so many
because
by
total
way of
area- madam, total area is 0..
2207.
Hectares. One single survey number. They are saying for others they have taken. For 3 persons, that is left 465 square meter. That they have not taken. How they can say this has been taken, this has been taken, and my land is following with that. So that means they know my land is not following in that area. Out of that 0.2207.
How are you enjoying this land? What are you doing over there? Cultivation. Oh, this is a hilly land.
Hilly land. 200 square meter
So,
purchased. Well, out of that, can we see how many persons are there? Some persons have been taken. How they are saying this has been taken, this has not. Now they are saying it's a big chunk of area and we don't.
was any inspection conducted?
Inspection was conducted. As per the report and inspection was conducted. And if Malad sees the report, says that regulation is one of the grounds or important in respect of the land there is survey numbers placed and NDPS 2 survey numbers are there. And as the land in question are not yet subdivided, hence not delineated in the map as maintained by the area authority, as a result of which demarcation of individual share in respect to the rate petitioner is not possible at this juncture.
You know what is happening? It's a big chunk of land. Nobody's portion has been demarcated, so it is undivided for everybody. So
Has to be subdivided among all.
how will you subdivide? In a joint property, each and every co-sharer has right in each and every inch of the property. So if we look at it in this manner, how could you ascertain compensation in respect of others and not for him?
Some portion of land we have acquired. How they have.
Very well. You have acquired, but who is the owner of the land? How could you decide? Because it's a joint property and he also has share in that property.
That property we are not acquired. Some other. Survey number.
The land is undemarcated, so you could not have.
Survey number is different.
No, she says it's same.
It's page 26, hello?
Only in respect of, we are concerned with only in respect of survey number 144 by 2 by P, not in respect of any other survey. If you give compensation, then the petitioner will also be entitled to pro rata compensation. Do you get it? Only in respect of one survey number, there are 10 claimants, there are 10 co-sharers. Nobody's portion, very well, 7. Nobody's portion is demarcated. How could you understand as to this portion is Mr. X, that portion is Mr. Y, and you compensate X and Y and you leave out Z? What is the mechanism that you adopted to ascertain compensation?
This case, it should not come.
Why not?
What case doesn't come under that, for compensation? Since her land has not been applied.
How do you ascertain her land? Tell me, it's an undivided portion of land.
Land, why? Some other survey. It's not from.
Kindly see page 27, the same survey number, 144/2/P. Total area 0.2207 acres, names are mentioned, Sushila Mandal, Neeraj, Chandraban, Durgavati Devi, BC Sheel, Samantha, Rani Das, Sudha Bhattacharya, and thereafter, it's DK Push, Gautam Mandal.
26, 1 minute, 20, 1 minute, 26, 27, 28 are the names of the persons whose land has been acquired or not been acquired. And there are four boxes. One serial number C, 1, 2, 3, 4.
Annexure 8, annexure 8.
Page number, please. Preliminary report, yes. Yes.
First is, regulation's name will come in the middle.
Her name is
Name of witness.
Snehomoy De. Yes.
The next list, if I want comes is Sushila Mandal and others. Name of the witness is Sushila Mandal. The name has been deleted.
These are witnesses. Are they the
They were the recorded tenants.
they are the recorded? All right. 1 minute, please. Yes.
Their names which they have acquired, the Sushila Mandal, Aparna Mandal and all.
Hmm.
So they have deleted them.
Now only 3 left, madam.
Under which survey number is this?
Under 144 of this, only 3, madam.
By four by P.
Even I'm admitting, madam. Others have
They
been,
are addition of survey number.
others have been taken, three persons have been left. Now in the records of right.
Is it your case that the petitioner does not possess any land in this one for he possesses? If he possesses any portion of the land and the entire chunk of land is undivided, how do you ascertain as to whose portion you have acquired and whose you have not? What can be the mechanism? Do you get it?
Kindly see page 16 and 17, madam. This is the records of right. Now, the 3 persons who has been left out from the award, that 3 persons' names are there. Now the area also reduced, 657. Page 16 and 17, madam. The survey number is 144 of this 2/B. These 3 persons have been left out from the acquiring procedure, madam. And these persons' name now appearing in the records of holding register.
Where is the survey number?
Survey number, madam, it's in between, madam. First name is there, madam. In page 16, madam.
Page 16.
Down here, the 3 names are.
Yes,
there.
survey number is there,
Survey number,
144.
area, everything mentioned.
Right.
Everything mentioned.
The share of Gulapi has been mutated in the journal.
So now only 3% whose lands have not been acquired as per the award.
Has any order been passed by the authority?
Well, they are asking me to bring sketch map, they are asking FMB is not there, all these things, they are the competent authority, my lord. The Tahsildar, he is keeping all the records, my lord. He is maintaining.
Is 46 the communication or the notice by which you are aggrieved? Filed a petition regarding demarcation.
Pending, my lord. My
Page.
petition is page 43. Thereafter, condition, I have paid the fees, demarcation fees 44. Thereafter, they have given the notice 45, my lord. 45. Then now they
46.
have given 46. Now what I am saying, my lord, if the land is not there, that means it has been acquired. Either you give the land or you give the compensation, my lord, as per the market rate.
Is it your case that the land is not there?
Because, no, I'm saying the land is there. That's why no, my lord, first I have given the.
You are not in possession.
Now I am not in possession. So demarcated.
Who is occupying the land? Somebody else.
No, we don't know, because it was a chunk of land and some portion of it. Now only 643. Out of that, these 2% they are occupying the land. Another 2%. Out of 3, 2 are occupying. My land I am not able to get it. That's why for demarcation, they are saying it's not being compensated. The acquisition proceeding.
Please come.
And all these records, the Tahsildar is having all these records. Either to give compensation or to give land.
The petitioner claims to be the owner of certain portion of land in survey number 144 by 2 by P. Stop. The petitioner relies upon the record of rights in support of the ownership of the land. Stop. He seeks demarcation. Stop. A notice was issued by the Tahsildar to all the stakeholders for demarcation of the subject land by the revenue inspector. And the revenue inspector has submitted a report that the map of the subject land is not marked in the FMB. Stop. Paragraph. The petitioner has annexed document to show that portion of the land in the aforesaid survey number has been acquired. But petitioner's portion, but according to the respondent authority, the land of the petitioner has been left out of acquisition. As acquisition did not affect the land of the petitioner, he was not paid any compensation. Stop. Paragraph. The petitioner submits that out of the huge chunk of land in survey number 144 by 2 by P, only a small portion of the land in respect of 3 owners has been left out of acquisition. Stop. As the authority is aware with regard to the portion that has been acquired, accordingly, the balance portion of the land is liable to be demarcated, from which the petitioner can demarcate his share of the land. Stop. The paragraph, an affidavit has been filed by the Tahsildar signed on 13th of December 2024 by mentioning that the writ petitioner is one of the joint recorded co-tenants in respect of the land bearing survey number 144 by 2 by P, measuring about 0.0651 hectares, and the land is yet to be subdivided. The demarcation of individual share is not possible at this juncture. It has also been mentioned in the affidavit that the individual share of the co-tenants are not mentioned in the record of rights, as well as not delineated in the map as maintained by the area patwari. Stop. There is duplication of survey numbers in both the holdings. And the petitioner is required to approach the competent authority for subdivision of land under section 68 and 69 of the Andaman Nicobar Islands Land Revenue and Land Reforms Regulation, 66, read with Rule 48 of the Andaman Nicobar Islands Land Revenue and Land Reforms Rules, 1968. Stop. Paragraph. According to the Tehsildar, the writ petition is liable to be dismissed. Stop. Paragraph. On a perusal of the report, the court has failed to understand as to how a portion of a joint property could be acquired and compensation given to only a few of the co-tenants. Stop. It is settled law that in a joint property, each and every co-sharer has right in each and every inch of the said property. Stop. If the entire chunk of land in survey number 144 by 2 by P is acquired, then all the co-sharers will have a right to a portion of the compensation awarded to the land losers. Stop. Paragraph. Only if the land is divided and demarcated amongst the co-sharers, then the authority can ascertain as to whose portion of the land has been acquired, for which compensation has to be paid. Stop. Paragraph: in the instant case, the Tehsildar admits that the land is undivided and at the same time submits that the petitioner is required to apply for subdivision. Stop. The petitioner has a formal deed of sale in his favor and the area of land purchased by the petitioner is mentioned therein. Stop. The authority must be aware of the portion of the land which has been acquired. Stop. It has to be taken that no. The same implies that the balance portion of the land of the subject survey number which has not been acquired belongs to the petitioner and the other two co-sharers who have not been paid compensation for the same. Stop. Next. In view of the above, the Tehsildar is directed to conduct a spot inspection to ascertain and demarcate the land which has already been acquired. Stop. From there, it can be identified the portion which has not been acquired. Stop. The unacquired portion is to be subdivided amongst its co-sharers in the share purchased by each of them in the share mentioned in the sale deed. Stop. The Tehsildar is directed to cause the spot inspection upon prior notice to all the necessary parties. And thereafter take steps for demarcation. Stop. The Tehsildar shall endeavor to take steps in terms of the direction passed herein above within a period of 12 weeks from the date of communication of this order. The petitioner shall be intimated his share after demarcation.
Madam, other openings are there, may take some time.
12 weeks will not be enough. 16.
It's an area hardly 1 kilometer from the. It takes some time.
Very well. 4 months. Make it 4 months.
4 months.
16 weeks comes to 4 months only. I had earlier mentioned 3 months and there are so many co-sharers. Let us see how it can be resolved. 4 months.
Well,
Will the next one be the same? Oh, it's different.
WPS facility of 24.
I'm responsible of my son. But here I'm paid for
Interim protection.
protection with regard to this, the Pradhan has been, under the, no confidence motion.
Removed.
So till that time, no other person has to be appointed.
Did you implead all the other panchayat members as parties?
No, because. No, madam.
Why?
But on the
Are they
basis
not
of-
required to be made parties? No confidence has been moved against you.
Against the Pradhan.
Yes, that you are the Pradhan. You were the Pradhan,
I was.
right?
Yes.
So somebody has moved no confidence against you, and the court is looking at whether the no confidence was proper or not, and you will not make them parties. They will file another writ petition and say that, see, we are not parties, and how could the no confidence motion be looked into by the court without affording an opportunity of hearing to them?
But my lord, on the basis of, my lord, I'll.
Let me see. Well, show.
Legality, why the
Please show.
illegality I'm saying here.
Yes.
The first notice, my lord, the Andaman, as per the regulation, my lord, the 21 says, my lord, the, with regard to no confidence motion upon the Pradhan, my lord. Section 21. And section, rule 19 says about the procedure, my lord, how to follow. They have not followed all these procedures.
How many members are there?
My lord, altogether 12 members, my lord.
12. Yes.
My lord,
How many went against you?
my lord, the thing is that, my lord, two members, they have filed an application by saying that we have to move the no confidence. It has to be served upon the Pradhan first.
Yes.
It has not been served, madam.
Very well. Let us see.
It has not been served, and the meeting that was conducted by the secretary,
It has to be conducted by whom?
Pradhan or Upradhan or any member, not by the secretary. Not by the
Secretary alone?
secretary alone. That report is there, madam.
Please show.
I will draw the things, madam. But,
And who is the authority to look into all these things?
the deputy commissioner and we have made all the authorities party, madam. They are.
Please show the notice of no confidence.
P1 is the notice, madam. On the basis of this, the it has moved, madam. This is
Page
the
21,
21.
27,
2024,
no confidence,
They have
second.
given the notice by saying that the no confidence motion has to be taken against the Pradhan. This is the first thing. Thereafter, my lord, kindly see the panchayat secretary. He has given the notice to the general.
Special meeting to be conducted.
Meeting.
Right.
Who has
10.
conducted special meeting, madam? Page 23, madam.
Page, oh, 1 minute. Page 22. Special meeting to be held on 11th of October.
The date and time when you have everything mentioned, madam. In the second 22 page, madam.
Page 22.
23 is the meeting, madam. P3,
Who attended?
the members.
Everybody attended.
Madam, I was not knowing, madam. I was not given with any notice.
Page 21. Was it not served upon you?
No, madam. No, it has to be served first. Mandatory, madam. As per the regulation, it is mandatory.
Did you raise an objection?
In my.
Where is it?
Kindly see who has held this meeting, madam. 24, it is there, madam.
No, if the first notice is not served upon you and you get to know later on, where did you complain? The deputy commissioner?
No, in the second meeting, when I entered, in the Gram Sabha meeting, when I entered, from there also have been thrown out. That is also there. Myself, along with the other Gram Sabha members, it has been thrown out, and the others who are with them, their name has been recorded and their signature has been taken.
You must have complained somewhere.
No, madam, I filed this case.
Without approaching the authority, you filed the writ petition. You are required to raise a grievance.
Yeah, madam, the identical matter was to, in the year 2010, and this honorable court has entertained, madam. That statement I have annexed, madam.
Page?
Page 48, madam. It is with the same Pradhan. Firstly, madam, the reason has to be assigned. No reason has been assigned. If my lord will see all the documents I have annexed, there is no reason to remove me from the Pradhan, as a post of Pradhan. There should be some reason. Illegality should not be
Where is the last page of the judgment?
This is the last one. This is the last one, but, I couldn't get but the last page says, my lord, the respondents are directed to take position of the Pradhan and refrain from the action against the Pradhan, present petitioner being the Pradhan of the Hajinagar Gram Panchayat. In this, my lord, the same thing happened without reasoning. The Pradhan has been removed and this thing happened. Because there is a procedure, my lord, how to follow. My lord, kindly come, my lord, has having this entire resolution here. Rules, my lord, it says, my lord, 19. May I read once, my lord? May I read once, my lord? What is the procedure to be followed for removing the Pradhan under the no confidence motion, my lord? That is there, my lord. Regulation rule fixing. Regulation 21 says, once the rules. May I read the rules?
1 minute. Section 21?
Section 21, my lord.
Yes.
Section 21, says here, a motion of no confidence against the Pradhan may be moved by any member of Gram Panchayat after giving such notice thereof as may be prepared. This was done, madam. That is in Annex P1, madam. Thereafter, a special meeting of the Gram Panchayat shall be convened within a period of 15 days from the date on which the motion has been moved to deliberate on to decide no confidence motion. That also done, madam. If the motion of no confidence is carried by the majority of the total membership of the Gram Panchayat, the Gram Panchayat shall recommend to the Gram Sabha the removal of the Pradhan in his office. On receipt of the recommendation under section 3, the special meeting of the Gram Sabha shall be convened with a quorum of not less than 15% of the total membership of the Gram Sabha, and the recommendation shall be approved by the majority of members present and voting. Upon the approval of the recommendation under section 4, the Pradhan shall cease to hold office after a period of 3 days from the date on which. Now, the seventh is crucial, madam. Notwithstanding anything contained in this regulation, the Pradhan shall not preside over the meeting of Gram Panchayat contained under subsection 2 and Gram Sabha under subsection 4. But
1 minute, 1 minute, 1 minute. You do not have to go so far. Your rule 19(1) says that the notice which is addressed to the Pradhan
Pradhan
shall be delivered to him.
delivered to him. That was not delivered. That is the case, madam.
Yes.
It was delivered. That office seal is there.
Right. Since it was not delivered, so you have to raise an objection. Where did you raise that objection that it was not delivered to you? We have not crossed.
I've mentioned everything, madam. I've taken the ground. I've mentioned everything.
Anyway, who is the panchayat? Will you represent the panchayat also? No, possibly. All right, you will represent the executive officer of the panchayat samiti?
Chief Executive Officer, Jilla Parishad Executive Officer, Panchayat Samiti. Director, RDPR.
Yes, yes. Till respondent number 7, you will represent. Is there anything to show that this notice of no confidence was served upon the Pradhan? You have to take instruction. When is has the no confidence motion been accepted? Has it been accepted? Where is it?
Starts from page 45. Page 45.
Has charge been taken? What is the date? Page 45?
45 meeting, as per this meeting, they have conveyed because 45, 46 and 47 is the.
Yes, finally the motion of no confidence is passed successfully by the majority.
Out of that, 951 persons were there at the when the meeting started.
420
persons signed,
right.
That means the majority of the people not signed. Majority of the people not.
So what is the quorum?
951. Mentioned in the page 45.
Page 45.
The page 45, Lord. They have mentioned fifth line is.
What?
The citizen on 951 voters Gram Sabha that present themselves in the meeting started since.
What should be the quorum?
Second paragraph kindly be seen 46 second paragraph. The chairman stated the special Gram Sabha meeting and appraised about agenda of the meeting and request the Gram Sabha members is that manner further proceeding can be undertaken according. It was decided that the person who was supporting the no sit inside the community hall and those who are not supporting the no confidence motion that is to be do not want to remove the Pradhan from the post out of the campus and sufficient time is given to the take decision. So with Pradhan, the other members, they have removed from the community hall by saying that yes, who wants to be with the no confidence motion, they have to be stayed there. So my lord, the altogether how many persons they have signed, my lord? Kindly see for page 45. Page 45 they have signed. It's written 428, but after 426 it's 428. Skip the 427. That means 427% have been signed out of 951. If see my lord 951 minus 427, it's majority of the.
No, but the quorum is only 15% of the total members present and voting. So the quorum is there. There is no problem with the 15. 15. So the quorum is there.
And the second thing, my lord,
Tell me one thing. Did you serve respondent number 8?
After everyone. After the service also are fine, my lord. After everyone.
Panchayat secretary? Office of the Gram Panchayat. Ah, principal of the Pradhan Gram Panchayat. Very good. Please come.
And 92 also very relevant, my lord. The meeting shall be presided over by the Upradhan or in his absence, the members assembled shall elect one from them. So here the
petitioner
and everything.
Was the elected Pradhan of the Gram Panchayat Pahalgaon. Stop. A notice of no confidence under Rule 19 to 22 was Rule 19. Rule 19 was allegedly given to the Pradhan by two of the members of the Gram Panchayat on 27th of September 2024. Stop. The petitioner alleges that the said notice was never served upon the upon him. Stop. The petitioner did not have any occasion to know that the members of the Gram Panchayat were contemplating to move no confidence motion against him. Stop. Paragraph. A meeting was conducted on 11th October 2024, not meeting but special meeting. And the motion of no confidence was carried. Stop. Paragraph. The petitioner submits that the very initiation of the no confidence motion is faulty, and accordingly the subsequent steps cannot be accepted in law. Stop. Paragraph.
Page 21 itself speaks like this.
He has.
The Pradhan Gram Panchayat Pahalgaon. Seal is there. From where he got this notice? Seal is there.
That may be from somebody else. There may be supporters in his favor also. It has to be addressed to the Pradhan. It has to be addressed to the Pradhan, but whether it was delivered to him, where is the proof?
Specific. Is there, madam? Specific.
This has been received by him only.
No, not
That's why
necessarily.
this is annexed.
Show where is, this is what the court intends to see. Yes, this is the thing. What did I say? Right. And the copy of the writ petition was served upon the panchayat. Stop, none represents the panchayat despite service. Stop. Listen, I can send you to the executive officer of the panchayat samiti, or the matter has to be decided upon affidavits, because the court is not aware as of now. The court has not heard the panchayat. What would you?
But till that time, I will protect madam, because if it is notified, new Pradhan will come. Then what is the use of filing this madam?
The court can restrain further notification and let the executive officer see.
Till that time, I may be permitted to work madam.
No, but then this was passed in October. From October till
Not
December.
October, November, madam. November, madam. Kindly see
The meeting took place on the 11th of October.
No, madam. Last meeting, madam, it's at,
11th of October.
Yes, 11.
no, madam, it's 16/11/2024, madam. Connection P 7, page 30, madam. Connection P
Special
7,
Gram
page
Sabha
30,
meeting.
madam. On 16/11/2024.
Yes, from 16/11 we are approaching 16/12. 1 month will be nearly over and no steps have been taken to
But
notify
they are already started.
what they have
Will be
started.
Because now the, from 16, the High Court will not be there because the notice has already been given. And 6th is the next High Court, madam. So by that time, they will do it. In between 20 days, they will do it.
From the submission made by the parties and on perusal of the documents annexed to the writ petition, it appears that the special Gram Sabha meeting was held on 16th of November 2024.
3 days time, but there are.
Stop the notification regarding appointment of new Pradhan has not been published till date. Stop. The petitioner is yet to raise a formal objection before the executive officer of the Panchayat Samiti. Who will be the authority? The executive officer of the Panchayat Samiti. Stop. As an issue has been raised with regard to the procedural irregularities in conducting the meeting for removal of the Pradhan. How did I start the sentence? Right. Very well, comma. Accordingly, the same is required to be ascertained by the executive officer of the Panchayat Samiti. Paragraph. In view of the above, leave is granted to the petitioner to make a formal representation before the executive officer of the Panchayat Samiti, highlighting all his grievances and the illegalities in the and the procedural illegalities in the process of removal, in the process of his removal. Stop. In the event a representation is filed by the petitioner by Monday, can you do it? 16th? 17th December 2024, the executive officer shall take steps to decide the issue upon perusal of all records and upon giving an opportunity of hearing to all the necessary parties at the earliest, but positively within a period of 4 weeks thereof, till a decision is taken by the executive officer of the Panchayat Samiti, the petitioner, the no confidence motion that has been passed will not be given effect to. Writ petition stands disposed. Learned advocate for the petitioner is directed to immediately communicate this order to the Gram Panchayat.
Item number 5, WPS 688/2024.
Petition. That my copy of the complaint is at page 40.
Complaint regarding what?
Regarding illegal committed by the chief executive officer,
All right.
page 42.
Yes, that has not been considered.
Not considered.
My instruction is,
Please wait.
I was asked to take instruction.
1 minute, let me hear what the matter is.
Page 47 is the second one.
What exactly is the illegality?
My lord, actually, my lord, page 13 first name is
13.
13.
Yes.
This is the letter, my lord, sent by one U. Nasser Khan, requesting the chief executive officer of board Jilla Parishad, and here Jilla Parishad Nivas, to constitute ad hoc committee.
Why? There is no regular committee over there?
No regular committee, my lord, for more than 9-10 years. Page 15 may be seen. He appointed ad hoc committee, my lord, in the wrong name.
The wrong name means?
The registered, it is unofficial name he used. Official name is Masjid Noor. Page 13 may be seen. Second line, the subject and the registration certificate.
Page 13, accounts of Masjidun Noor Masjid.
Yes.
And this is
This is
Masjid-e-Noor.
Masjid Noor.
So this is some other
Yeah.
WAP. All right. And the names of the members are of yours. These names, page 15.
Yes. Yeah, appointed in
The
wrong
names
name.
of the members are all right.
Members he appointed, my lord, in the wrong name of the masjid. Actual name is different.
I understand the
Yes.
name of the masjid has been wrongly mentioned,
Yes.
but the name of the
members.
committee members are all right.
All right.
There is no issue.
no dispute.
All right.
Now, my lord, kindly come to page 16.
16.
Masjid Noor, the correct
Right.
name was used.
Yes.
Now, my lord, we filed a suit initially, my lord, that was dismissed on maintainability ground. That order is page 37.
Before where did you file WAF tribunal?
Tribunal. Page 37.
And what was the relief that you sought?
I sought relief that the E-Noor name should not be used, the original name should be used. That was dismissed on maintainability ground. Dismissal order is page 41.
All right.
Thereafter, I filed a fresh suit, my lord.
Yes.
I obtained the order. Page 18 may be seen. Second suit.
How can you file a fresh suit?
That was maintainability ground. It was dismissed. I did not comply by giving a notice.
Oh,
Page 18 may be seen.
18.
18, yes.
Yes.
I filed a second suit.
Hmm.
Second suit, injunction was passed in my favor, and that was adjudicated. Finally, it was 36, the operating portion.
Yes.
36. The prayer of the plaintiff for temporary injunction against the defendants allowed on contest. Defendants are directed not to use unofficial name of the mosque, that is Masjid Noor, in place of Masjid Noor, till disposal of the suit. The initial mistake was committed by the chief executive officer. Chief Executive Officer is
Is
the,
it your submission that the mistake was deliberate?
yes,
Is there any other masjid by that name?
no. There is no other masjid in the name. And kindly see the bylaws of the work board, page 44,
Yes.
page 44. Kindly see the name
Hmm.
and kindly come to next page, my lord, page 45. Kindly see the name. Approved bylaws.
Yes.
The ad hoc committee, my lord, if the ad hoc committee appointed by the chief executive officer took possession of entire thing, there is misappropriation of around 3 crores. We lodged a complaint, FIR was also chopped out under section 409, 420 IPC, that is pending. We lodged a complaint because the chief executive officer, the grandfather for the entire wrongdoing. We lodged a complaint against the chief executive officer to the chief secretary.
That is pending.
For page 47.
Yes, I get it.
Here, one more slide. Page 2 complaints are there, Muga. Page
47,
42 is there, Muga. First
42.
42. First complaint is 42.
Yes.
Second complaint is
20th of November 23 and March 24.
it is pending. My prayer is this should be disposed of by the chief secretary after giving opportunity of hearing to us. One more important point.
Who are you?
I'm the one of the worshipper of the masjid.
Worshipper of the masjid.
Yes. The complaint was by me. It is there. My name is also there. Page 43.
Yes, I followed.
Serial number 5.
Is issue relating to the unofficial name used by the executive officer is pending before the Waqf tribunal. Still suit is pending. I have brought the copy of the plate.
Tell me one thing.
Injection order has been.
1 minute, 1 minute. Suit is there, everything is all right.
Yes.
Where from did you get this name?
This is, I taken specific ground my written statement before the Waqf tribunal.
Yes.
That it is sometimes pronunciation problem is there.
Well, if there is pronunciation
Yes, we
problem,
have said that
correct the spelling.
registration-
Pronunciation has got
We
nothing to
have
do with the
withdrawn that order,
spelling.
by which he is biased. I have withdrawn that order. That order has been withdrawn. The committee, which was wrong name, it was constituted, it has been withdrawn.
Sure, please show.
Not only that, my lord, they changed the board also.
We have not changed the
This
board.
color photo may be seen.
Yes.
They
Your
changed the board.
This is the order. This he shows you.
Original board is this one.
And for changing board, he filed a petition before the tribunal, which is fixed for hearing on 8 January.
Not 8 January, 16
Yes,
January.
whatever it may be.
You
but it is
are the
pending there.
authority. You are not here to generate litigation.
We are not generating.
If
the
you
litigation.
say that the initial, there has been a mistake in mentioning the name
Yes,
of
we
the
do- we
masjid.
have said the registration is same, but due to sometime pronunciation and typing, it may be mistake, but it's same identity of same institution.
If that be so,
Yes,
then his grievance is redressed and the suit also becomes infructuous.
They are
for
contesting
suit,
the
we have,
suit.
on which he is
By
making,
filing internal objection, they are contesting the suit.
no, we have said that as per order of the court, we will follow it, whatever order passed by the court, but it is the same.
Is the troubleshooter, my lord?
Same thing.
Wait.
It is some personal vendetta against the.
You
chief executive
have
officer
something
by-
else behind,
Yes,
up your cuff. You are not
There is something
disclosing
else
it.
there behind. it.
I can get what is
Yes,
playing through your mind.
My prayer is
You are a worshipper. Right. How does it matter whether it is Noori or something else? You go and worship over there.
Correct. They should do it correctly, my lord, in terms of the bylaws.
That has got nothing to do with your prayers.
That is nothing to do with the
What is your interest?
Misappropriation is there, my lord. I am lodging complaint
Yes,
against them.
right. So
We
it
have
is,
received 3 crores.
it
Against
is not
earlier
the,
committee.
it is not the name that is troubling you. What is troubling you is the misappropriation.
He is the grandfather for the entire troubleshooting.
Something is there behind this, all these things.
I lodged
Personal-
complaint, my lord. This
personal-
should be-
Wait, just wait. The matter has been re-examined in light.
That page which has shown that a wrong name has been used, has been withdrawn by the.
Just wait, let me see the papers. Has been received from such and such and has to.
page 15 of the petition has been withdrawn.
And where is the representation ad hoc committee was constituted? In between.
Where may be seen now?
Representations prayer may be seen. It's the same issue which has been dealt with by the tribunal and
No. The complaint is against chief executive officer. I'm not claiming any property right.
so personal grievance is there against
No
the.
question of
Must
personal
be
grievance.
And I will show one notice also giving threat to the chief executive officer to lodge FIR against
Yes,
him
what much? Very.
Was
without
constituted in the name
any
of
client's
Masjid
instruction.
and the ad hoc committee considered is hereby dissolved. 14/8.
I have mentioned in my complaint,
14/8/23. Page 15 has been withdrawn.
Mela. I'm not concerned with the withdrawal of page 15. Mela.
Yes. You are not
Because withdrawn
concerned.
Latest, very latest.
Yes.
I'm not with that. My complaint may be seen page 42.
Please come.
Mela, page 42 may be seen.
The petitioner claims to be one of the worshippers.
Mela, 5 petitioners are there, not single.
All right, petitioners claim to be the worshippers of a masjid by the name of MASJIDUN.
Subject to approve. My prayer may be seen.
I am coming to it. MASJIDUN. Did I spell it properly?
Correct.
Space NRR space MASJID. Stop. A request was made by the one Nasir Khan. Nasir Khan is not a party, isn't it?
Nasir Khan is the filed the suit, page 17.
By one U.NASAR-KHAN. In the month of August 2023, before the Chief Executive Officer of the WAF Board, with a prayer for constitution of ad hoc committee for conducting election and also for auditing the accounts of the said masjid. In response to the said request, the Chief Executive Officer, by a communication dated 14th August 2023, addressed to the Secretary of the Masjid regarding formation of new ad hoc committee, but the name of the masjid was wrongly mentioned. Stop. The name was mentioned as MASJID -E is small and hyphen caps NRR. Stop paragraph. It is the submission of the petitioner that the recording of the incorrect name is deliberate and there is huge financial misappropriation taking place in the said masjid. Stop. A request was made before the Chief Secretary of the Andaman of the administration complaining against the chief executive officer, who, according to the petitioners, is creating all the problem. Stuff. Specific allegation has been made against the chief executive officer paragraph. A suit has been filed before the Waqf tribunal challenging the illegalities of the who are your defendants?
Unofficial name.
Who are your defendants in the suit
Chief Executive Officer
against the chief executive officer
and a committee member.
and against the committee members? The said suit being WT case number 02 of 2024 is sub judice. The an interim order has been passed by the tribunal by directing the defendants not to use the unofficial name of the mosque in place of the official name till the disposal of the suit. Paragraph. Where I mentioned an interim order, please mention the date. Dated
6th September 24, page 28.
6th of September 2024. Next. As the earlier representation before the Chief Secretary filed in November 2023 remained undisposed, further representation was filed on in the month of March 2024. Stop. It is the specific submission of the petitioner that behind the incorrect name of the masjid, the chief executive officer and the committee members are continuing with the financial irregularities. Stop. Prayer has been made to direct the chief secretary of the administration to take appropriate steps against the chief executive officer to redress the issue. Any further prayer?
Page 6 is the prayer.
Okay, my submission is that representation was sent to the chief secretary officer from the office of chief secretary through the revenue section.
Forwarded to the revenue section. Stop. Paragraph. A communication of the chief executive officer, not communication, an order dated 5th December 2024 by the Chief Executive Officer has been placed before this court by the learned counsel representing the respondent number 2, wherefrom it appears that the ad hoc committee constituted vide letter dated 14th August 2023 has been dissolved. Stop. The order mentions that the mode of election of the person who can operate the account of Masidun MASJIDUN NWR opened on 26th of June 2013 and subsequent follow-up actions, such as, conducting membership drive and holding election for having a regular committee shall be decided subject to the outcome of the suit being WT 02 of 2024. Paragraph. Upon hearing the parties, it appears that the representation filed before the Chief Secretary against the Chief Executive Officer has been redirected by the Chief Secretary to the Chief Executive Officer. Stop. It is not understandable as to how the Chief Executive Officer will conduct inquiry against the allegations made against him. Stop. The Chief Secretary ought to have taken steps to consider the representation against the Chief Executive Officer through a different authority and not by the same person against whom the allegation has been made. Stop. It is settled principle that one cannot be the judge of his own case. Stop. In the instant case, the Chief Executive Officer can certainly not judge the allegation leveled against him. Stop. Paragraph. In view of the above, the instant writ petition is disposed of by directing the Chief Secretary to consider the representation. Consider the representations dated 20th of November 2023 and 18th of March 2024, strictly in accordance with law and upon giving prior opportunity of hearing to all the necessary parties and by passing a reasoned order at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. Till a final decision is arrived at by the Chief Secretary, the banking account of the MASJIDUN NWR Masjid shall remain inoperative. No, right? Shall not be operated by any person whatsoever. Stop. It is only after the order is passed by the Chief Secretary. No, the Chief Secretary shall consider and the Chief Secretary shall consider as to whether the order restraining operation of the bank account of the masjid shall continue or not. Disposed.
Since no affidavit is filed, allegations made in the writ petition.
Since the writ petition is disposed of without calling for any affidavits, the allegations made therein are deemed not to have been admitted by the respondents.
Number 6, WPS 704 of front of the floor. Just sitting under when someone put dispose of my representation, which is standing before the deputy commissioner, not the middle and the man. Who is the competent authority to dispose of it.
Representation for what? Regularization of encroached land.
My father, who was brought in silent in the year 1922 as a convict, he has encroached certain portion of land. Your lordship might kindly come to page 10, your lordship. I've enclosed the exact copy of the register maintained by the Tehsil concern. Case number 186 and 1.
You are Bashir Ahmed.
Hi.
Your father?
Same Mohammed. Case number 186 provision.
Page number 10, serial 186.
Enclosed by Sher Mohammed. 1, 2, 3, 4.
Yes, Sher Muhammad.
And 189.
189.
Enclosed by Sher Mohammed.
Sher Muhammad. Hmm. Very well. Do you have any other co-sharer?
Yes, sir. I paid that after hearing all the parties concerned.
Please come.
In my prayer,
The representation made by the petitioner seeking regularization of the encroached land is pending consideration at the end of the Deputy Secretary, Deputy Commissioner, comma, North and Middle Andaman.
that me of my Please.
Paragraph. The petitioner claims to be the descendant of one Sher Muhammad, who encroached upon certain plots of land, and the name of the encroacher is reflected in the Khosra register maintained by the authority. Stop. Without entering into the merit of the prayer of the petitioner, comma, the instant writ petition is disposed of by directing the Deputy Commissioner, comma, North and Middle Andaman, to consider the representation made by the petitioner in accordance with law after giving reasonable opportunity of hearing to all the necessary parties, and dispose of the same by passing a reasoned order at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. Next. If required, the Deputy Commissioner may cause a spot inspection to ascertain the genuinity of the claim of the petitioner.
Well, seven, WPS 709 of 144. I am filling on the petition. Service left from affected.
Very well. Service is not complete. Next circuit, service in the meantime. Mention learned advocate for the petitioner submits. Service is not complete.
Number 8, 501 of 2024.
Lordship, I am appearing for the response. Just today morning, I have received the call from my learner.
Go through it, see if it can be disposed of.
Lordship,
What is your prayer?
to grant, to dispose of the representation.
Then let it be done.
Lordship, because in some of the cases, I found that they have withdrawn the application from the department. So let me take instruction.
Monday?
Let it be in the next circuit bench, because
You try and see if it can be done on Monday.
it is case of Diglipur, Lordship, so it is not possible on Monday.
All the procedure has been done by the respondent number 1, it's superintendent engineer.
No.
Let me see the
Superintending
file
engineer
once.
is merely the higher authority.
You have a copy of the brief?
Just
Page
today
9.
morning, I have.
Very well, please see page 9. There is an application 22nd of December
Lordship,
2023.
as per my instruction, Lordship, online application is not accepted there, Lordship. It is offline, he has to file. From Port Blair, they are filing online application, but it is not accepted.
There is no.
There is no online facilities available in the Diglipura, North and Middle Andaman Island.
What do you mean by it is not available from a particular place? He can put it up online from any place he wants.
No, he can, but
Then
our officer do not have that access. Now we are improving the things. We will improve within a month.
well, you say your officer doesn't have the access. It is nearly 1 year. Why did your officer did not
Lordship,
intimate?
online application he did not receive. Even in some cases, I found that they have filed the offline application that has been considered. It is not that we are not considering. So let it be in the next circuit. When Lordship, let me take the instruction. Today itself, I have got the
The
instruction.
petitioner seeks new electricity connection. Stop. Learned advocate representing the electricity department seeks time to take instruction. Prayer has been made to post the matter in the next circuit. Stop. On such prayer, list in the next circuit.
Obliged.
WPS 683 of 2024.
6. Lordship, I have received the report, Lordship. Here also same, Lordship. Offline application because it is belong from Bharatan.
Filing the application through online mode or.
They can apply, but if they are not.
Earlier, there are many orders passed by this honorable court, like considering our application. If it is not acceptable by the.
Lordship, let me file opposition in this matter.
Yes, Your Honor.
Let me file opposition.
Why? Only because he filed online application, he'll file opposition.
No, Lordship, because Bharatan, there are forest land also.
Yes.
In forest land.
Very well, please come.
Mentioned.
Very well, please come. The petitioner's application seeking new electricity connection. Filed online on allegedly filed online on 26th October 2024 is pending disposal at the end of the electricity department. Stop paragraph. Prayer has been made to direct the department to provide the new electricity connection. Paragraph. Learned advocate representing the department submits that online application of the petitioner cannot be accepted. Stop. The petitioner is required to file application offline. Stop. Paragraph. Any other objection?
No, Lordship. Let him file the offline application within 1 month as per the law. Will consider.
The submission of the department for not proceeding with an application submitted online cannot be accepted. Stop. Copy of the application filed by the petitioner is annexed to the writ petition. Stop. The department is directed to consider the said application being online application number 25377 dated 26 October 2024 annexed at page 10 of the writ petition in accordance with law at 10 and 11 in accordance with law at the earliest, but positively within a period of 6 weeks from the date of communication of this order. Stop. If the department is if the application made by the petitioner appears to be proper, then consequential steps for giving electricity connection shall be taken forthwith. Stop. If there are deficiencies in the application, the same shall be intimated to the petitioner so that steps can be taken to rectify the same. Disposed.
Item there.
10, Lordship, I have received the report. I am placing it before this.
Yes, please.
Sorry, I have marked it, Lordship.
Doesn't matter. Applicant has not done wiring and earthing. Why don't you tell him that did you intimate that this is what you are required to do?
Before filing the application, they have to do it, Lordship. In application, they are mentioning that we have done this, we need this. All the things department will do, Lordship.
These facts comes today only. And I undertake that
Do you have a copy of this document?
No, Lordship, I will take direct and,
Make a photocopy and hand it over to him so that he can take steps accordingly.
yes,
I undertake that within 2 days, I will complete that procedural work.
The application filed by the petitioner seeking new electricity connection could not be allowed because certain defects were detected at the time of inspection. Stop. The petitioner is yet to be made aware of the deficiencies that she is required to rectify. Stop. Paragraph. Learned advocate representing the department has placed before this court a communication made by the assistant engineer Roman 2 within bracket HQ addressed to the executive engineer within bracket HQ dated 12th December 2024, mentioning the reasons for not granting electrical connection to the petitioner. Stop. Let a copy of the same no, write one more line sentence. It appears that the application stood rejected on the ground, rejected with the remark for submission of either ration card or electoral identity card mandatorily having the same address as a proof of occupancy of the premises. Stop. Then let copy of the same be served upon the learned advocate representing the petitioner for rectification of the deficiencies. Stop. The department shall provide electricity connection to the petitioner within a period of 4 weeks from the date of removal of all defects. Disposed. Please make a photocopy of this and hand it over to the petitioner. I will keep this on record. The instruction be written with the records.
Item number 11, WPS 687 of 124.
Lordship, we will consider and dispose of that. Same order may be passed. On 9th December and yesterday also your Lordship has passed there.
Online. Page.
We will consider and dispose of Lordship. If already connection is there, we will intimate, or if it is not there, we will consider and dispose of. If she has fulfilled everything.
One order be passed. Online application to be considered. Application is at page 11. And the application number is also mentioned. The date is also mentioned. Disposed. Item 8 also could have been disposed of with this order. You posted a
No, Lordship, because
very well.
I
If
have
it is
faced difficulties
if
so
it
only,
is if
otherwise
it is
I
because
could
it
not.
is all right.
Item 12.
Lordship, just today morning I have received this brief.
It has been rejected.
Just today,
They want spend his endorsement.
Yes.
Lordship, just today morning I have received the brief. Let it be on Monday. Let
All
me
right,
take
all
the
right.
inspection.
I'll just look at it. Which 22?
The remarks column, they want registered sale deed.
The updated sale is not valid. Uploaded, registered, recorded in your name.
Yes, yes. Employee sale agreement is there. No employee sale has been.
No, it is not recorded in his name.
No. Sale agreement is there.
Sale agreement, everything is there.
Agreement
Deed is there.
Record.
Record
Page
entry.
number 80. Just a minute. Page number 80. Correction P1. Record entry. And NOC is there. No objection has been given by.
Your name is Tusi Das.
Vijay Kumar is sold. Can you see the last name?
Agreement, when is agreement?
Vijay Kumar has sold it to you.
Yes, page number 14, sale agreement.
Suppose the agreement does not mature to a contract or a deed, what will happen?
Defective, notice has been given, notice has been given.
Maybe just think of a situation, even after entering into an agreement, the deed is not executed.
But it does not provide a right, actually does not provide a right, my lord. It's only for purpose of using when they are using premise, that's all. It's not
Whether you are in possession or not,
Possession, agreement is given.
As per sale agreement, everything is
where
given.
will you take instruction, come back on Monday
Lordship.
to allow the learned advocate representing the department to come ready with proper instruction on Monday, list on Monday.
Seventeen, WPS 17, 6 of 2024.
17, 13.
I took 13, WPS 17, 6 of 2024.
13 to 15 I have, whether they have served or not, I don't know.
Service is not effective.
Very well, service not complete, next circuit. 13, 14, 15. Not affected. Next circuit, very well.
Let them provide me a copy.
Provide your learned friend a copy so that he can take instruction. That will save the cost of posting it.
No, Lordship, then also they have to serve it because otherwise monetarily I will not be benefited.
How can that be?
Lordship, because
You can.
I can receive the copy, but I have to receive the instruction. They will say
You receive the copy and you forward it to them. They'll give it to you.
let them serve 2 copies to me, so I can give 1 copy to. Obliged, Lordship.
Item 16.
I am taking from the petition, my lord.
Yes.
The documents, we have some request that we have got for 240 days. My lord has asked them.
Did you go through it?
Now, we have gone through this, now this document says that they have not, it says regarding the payment, that payment is for 240 days has been made.
Yes. So what does this
No,
mean?
but there are certain discrepancies, but kindly just see if suppose that section is clear enough, it says that if someone works continuously till 240 days. Now, suppose if there are gaps in between this, payments are made, might be payments are made at a certain after the entire work has been done. That is a different thing. So those things are there. Certain. Second thing is that only 30%. This my first prayer is not to make for not today, praying for not because my senior is on his legs before in a execution matter, my lord. But second thing is that the remaining 10% accounts are not being given to us. I have also requested them to check out the mandates because these are very old records. So that mandates is also
Please
like
come.
to be looked into.
Please come. Learned advocate representing the respondents is directed to file a report apropos the documents submitted by the petitioner in support of the submission that they were in service for a period of 240 days in a year.
My lord, one thing, may I submit one thing, my lord?
Yes.
My lord sees page 53, it is not the case of the second party before the trial court that we have not completed 240 days. Their only case is that there is no employer-employee relation. And the court arrived to a definite finding saying that employer-employee relation is there. My lord, kindly once come to page 53, my lord, there stand. And thereafter the finding, my lord, I have shown, my lord, I will not, if it comes to my lord that it can be, my lord, may kindly come to page 53, paragraph number 26, 27, and 28, my lord. Now, my lord, they categorically says in para 26, if my lord sees, it is further submit that section 25F of the Industrial Dispute Act is not applicable in the case of first party as the first parties were engaged on mandate basis as and when required. So they say that there is no question of 240 days complete because they have not worked under our direct supervision. My lord, the labor court arrived to a definite finding saying that there is an employer-employee relation. This is the only ground which they have taken before the trial court that we have not directly engaged them. And that.
No, at the same time, if I can recollect properly, the submission was made that the persons did not work for 240 days.
This is not their case. The finding of the labor court is there.
Yes.
Labor court says, my lord, they did not able to demonstrate that lastly they have worked for 240 days. Whereas the clear case is that they have worked for more than 11 years.
Yes, this is what you
And
submitted.
my lord, there is no departure from the said fact in their written statement and before the trial court. So, my lord, that was not an issue at all, my lord. And I have filed the document today. My lord has asked them only to ascertain whether from this
Yes,
document
yes,
it
yes.
reflect that 240 days or not. My
Right,
judgment
right,
says
right.
From the document, it reflects that 240 days they have completed. Now, my lord, it cannot be enlarged the scope of the.
So writ petition and the order of the tribunal.
My lord, I pray, my lord, let an order be passed because already my lord has heard both the parties at length, my lord. And if my lord sees the last order, last to last order, my lord has fixed it and my lord has said me, if you file the document, you are in, otherwise you are out. And there is an order to that regard to produce the document. I produce the document. They have seen the document. They say, as from this document, it reflects that 240 days are completed. So, my lord, what remains, my lord? It cannot be, my lord, at their.
No, but Mullah, there are certain judgments of this court only in the that is also under challenge, where court has sent back the matter again to the labor court where it is upon reinstatement.
You
Because
want these labor matters to move from high court, from the labor court to the high court and again to the labor court?
No.
Where will these people go?
in that we have bring three judgments of the Supreme Court. We have shown that Mullah, reinstatement is not in today's days, Mullah, it is something. That is something drastic, because today we have to look
Case
whether we
one
have
thing,
forced or not.
delete this line, delete this sentence, right? That learned counsel for the respondents seeks time to rely upon judicial precedents in support of their case. Stuff. List in the next available circuit. I cannot help. I tried to, but I failed. Today's list.